Proceedings were set to begin at the start of October, and just 2 weeks before the trial, the bombshell landed, as Darrell Brooks's public defenders officially submitted a motion requesting removal from the case, clearing the way for him to represent himself.
Even the angry outbursts that we've seen in court, the avoidance in his responses to questions asked.
I object to that because at the end of the day,
I understand Mr. Brooks, please stop. You can object. Your objection is noted. I'm going on.
This was followed by a desperate plea from his own mother, calling him unstable and his proposal to represent himself a bad idea. The judge noted the difficulties with dealing with the accused, but he was quick to clap back at the judge, even then.
You're reading from something that I haven't been privileged to read myself.
This is a prime example of some of the difficulty with Mr. Brooks.
I don't think you have a PhD, Your Honor.
The judge granted the request, and Brooks would face 76 charges, all alone defending himself.
And from this point forward, Mr. Brooks will proceed as his own attorney.
Starting at 9 a.m., at 9:10, the judge had already had to impose a break in the session. Brooks, defiant from the jump, refused to acknowledge his legal name and derailed proceedings with many interruptions. 40 minutes later, another breakdown at 9:43 a.m., and another ordered break. Brooks refused to go on and demanded the judge's name and a copy of her oath of office. By midday, the judge had had enough. She exiled Brooks to an adjacent courtroom, forcing him to appear via video feed, a move that let her mute his mic, with him looking like a reality TV villain. The grueling 2-day ordeal saw jurors struck down at random because of Brooks's relentless grandstanding. From a pool of 300 people, in the end, 12 jurors and 4 alternatives survived the chaos. 10 men, 6 women, notably all white, with 12 brave souls on the jury, willing to endure one of the most unhinged trials in recent memory to put away this evil killer. The jury was not present for Wednesday afternoon's hearing to discuss final housekeeping matters before opening statements the next day. Brooks opened with a curveball, claiming to have COVID and demanding the trial pause until Friday for test results. Yet he refused a rapid test, saying why take 2 tests for the same thing. Prosecutors revealed that the defendant was heard on a jail phone telling his mother that he was going to delay the trial with this tactic. During a back and forth in the courtroom regarding the COVID protocols, things got quickly heated between Brooks and the judge. Brooks, in his orange jumpsuit and leaning over his desk towards the judge, casted a menacing figure.
So I'm not arguing with you, sir,
I just want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
because
because
I don't consent to that, Your Honor, because
you don't have to consent. But here we go.
Let me to being cut off right when I'm trying.
All right, I'm just going to talk over him for a minute. I do not have any other information regarding the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request.
Brooks later played up the COVID angle, claiming he felt fatigued and had lost his sense of taste, and said he was afraid despite being fully vaxxed, but refused to discuss the details of his test.
So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue, and I have to wait for the results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain, and I find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff when there's a witness list involved. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. Like I said, I've never had this happen.
He was put in an adjacent courtroom again for all his disruptions, but Brooks still managed to cause issues, this time holding up a big blue objection placard. When the trial officially started, we would begin to see footage from the proceedings. Darrell Brooks seemingly hadn't even read his own discovery, the information and evidence from the prosecutors to prepare his defense. Despite recommendations from the judge to wear a suit and tie, Brooks came to court in his orange jail uniform.
The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody.
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody.
Within moments of the proceedings getting underway, Brooks had interrupted Judge Darrell multiple times.
So
Mr. Brooks,
I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
Just weren't speaking,
all right,
so
Mr. Brooks, you are now going to be removed to the other courtroom.
I don't consent to that.
He was again exiled to the adjacent courtroom, where a furious Brooks appeared in the video call, shirtless, pacing back and forth.
At 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items.
The judge says that his behavior was intended to make a mockery of the court, adding that his mental examinations revealed no competency concerns. During the lengthy process of the judge reading jury instructions, Brooks held his objection sign up the whole time before weirdly tucking it into the front of his pants. He would be allowed back into the courtroom, only to be kicked out again after claiming a juror flipped him off on the way in and out of the court.
Noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out.
The prosecution finally opened with their opening statements. Their intent was to provide evidence to prove that Darrell Brooks was responsible for the deadly events of that day.
The evidence is going to show that Mr. Brooks left behind a trail of carnage and chaos.
They explained that he had been fleeing from another crime scene where he'd laid hands on a woman.
The evidence will show that he left that crime scene, created that crime scene in fact, because he was fleeing from another one. One where he had laid his hands on a woman and where police involvement became inevitable.
The argument with the mother of his child served as the origin to his rage that day when he plowed his car into an innocent crowd.
You're going to hear about the origin of Mr. Brooks' rage that day. A violent domestic argument with Erica Patterson, his former girlfriend and the mother of his child.
The first witness was his baby mama's friend. Brooks asked the witness about something that she claimed she heard him say. When he had to read her written statement, which had swear words in it, he skipped the swear words because he said he doesn't cuss.
After a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to the effect of, I don't swear, so F you, effing bees, you're dead. Did you at any time hear anything like that?
Yes.
The implication was that if he doesn't swear, then who could have been this cussing doppelganger? A strategy that might have seemed smart to a stupid person, but this is all that he could try, and the court would bend over backwards to let Brooks dig his own grave. The judge was incredibly patient and would always let Darrell complete his nonsensical arguments. This was all done to ensure that Brooks was given a fair trial, despite his unhinged and psychotic behaviors, because mostly they wanted no appeals, no mistrials, and no escape. He would hang himself with his own words and have no pathway to getting out on a technicality, which was why the prosecutors even came to his aid throughout the trial to ensure that this madman was given a fair shake and no appeal.
No, I'm not. Are we both privy to the same pre-trial procedure?
There was a pre-trial ruling about
Do you want her to answer that question, or do you want to move on?
I want to move on.
One of Brooks's tactics to delay court proceedings would fall apart at the end of the week, when the judge found out that he had received his COVID test results, which he refused to present to the court, the judge instructing her deputies to take it by force.
Brooks, I was provided with information that your test result was hand-delivered to you, folded. Did you receive that?
I was made aware of my I didn't look at it yet, so may I ask the reason why that would be?
Mr. Brooks, you raised this issue yourself, and I'd like to know the result.
I would too, but I was kind of in the middle of preparing for my defense, so
Mr. Brooks, find the piece of paper and open it up and read it, please.
I will not consent to that, Your Honor. Or do I agree to that, Your Honor? I do not.
Mr. Brooks, then I'm going to advise the Sheriff's Department to find the piece of paper and hand it to me so that I can read it.
The negative COVID test was read to the court by the judge.
But I can confirm that the test result for COVID-19 was negative.
A shaken Darrell Brooks sat in the adjacent courtroom and broke down in tears as his first scheme to dupe the courtroom fully failed. Even back in the courtroom, Brooks would continue to make nonsensical remarks, like questioning why an officer was looking at the jury while answering questions about responding to injured victims.
Overruled, he may answer.
He's at the ground, Your Honor.
Overruled, he may answer.
So is he gonna answer to the question to
Yes.
the prosecution table or to the jury? I'm not sure. He's looking at them answering the questions, but they're not answering the question, asking the questions.
You may answer the question, sir.
The three individuals that I met with initially had band uniforms on, and it was my understanding that the band from that vicinity right then and there was a high school band, so I would place them all at teenage age range.
Brooks would go on to question the responding officer, making an absurd point that if he's still being paid his salary to testify, that he's de facto being a paid witness, and continuing to admonish him for looking at the jury during testimony.
I noticed, Officer Phillips, you are in uniform this afternoon. Were you scheduled to work today?
Yes.
So it would be fair to say that you would be on duty as of now if you weren't giving testimony in this matter.
I would be on duty right now, yes.
So it will also be fair to ask if it would be fair to say that you giving testimony right now, you're still getting paid for it?
I am currently employed by the City of Waukesha Police Department on a working patrol shift, on a normal shift for myself, yes.
So with that, would it be fair to say that you are getting paid right now as we speak?
Yes, I'm getting paid right now.
By whom?
Objection, relevance.
Sustained. Next question.
As the trial continued, Brooks was put on timeout in the adjacent courtroom frequently. He began showing up to court in a suit and tie and apologized for last week's behavior.
I apologize to the bailiffs, that I apologize for my actions. Like I said, that's not how I was raised. I come from a Christian background. My mother did not raise me that way.
Despite managing to stay out of the isolation zone for the week, his demeanor remained incredibly unhinged. Each time somebody mentioned Darrell Brooks, he flatly denied any connection to the name.
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by that name, nor do I know anybody by that name.
Your objection is noted. For the record, Mr. Brooks.
Objection. I do not consent to being called that name, Your Honor, nor do I identify by that name.
Tensions escalated when prosecutors played audio capturing the moments the vehicle struck the high school marching band. This harrowing recording sharply contrasted Brooks' emotionless face and the evident trauma of the band director. Brooks, who had been arrested with dreadlocks, shaved his hair during incarceration, bringing up the fact that he currently had a shaved head, yet the officer described a suspect with hair as if this might somehow save him.
Would it be fair to say that the alleged defendant that you just identified on the record for the court does not have hair?
You have shaved your head, yes.
Would it be fair to say that you have not seen the alleged defendant shave his head?
Brooks aimed to challenge the eyewitness testimony linking him to the car, while suggesting that whoever the driver was, they were honking their horn during the incident, proof that people were not intentionally targeted.
Would it be fair to say that that was just a horn that was heard?
No, I don't hear a horn.
You don't hear a horn?
I do not hear a horn.
Can we start that from the beginning?
Brooks' strategy fell flat, and one particularly damning moment came when a detective said flat out in front of Brooks that he indeed drove through the parade, with Brooks' mind games doing little to help him.
Do you remember what you can recall?
Do I remember if I can recall?
Do you remember the disturbance you recall?
Yes, I do.
Would you state what that is? What that was, rather?
I heard a horn beeping, and then a Ford Escape came through the parade route, and you drove past me and wouldn't stop, and you continued driving into the parade route.
Who is you?
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by that name, nor do I know anybody by that name.
Brooks was absolutely cooked, as the prosecution calmly asked if the driver of the red SUV was in court, and they repeatedly identified Brooks as the driver.
Do you see the driver of the red SUV in the courtroom here today, Officer Schneider?
Objection, hearsay.
Overruled. She may answer.
I'd ask Mr. Brooks be directed to remove his mask so that Officer Schneider can identify him, please.
Objection, I never heard an answer to the question.
It has not been answered, Mr. Brooks. Please remove your mask. Thank you.
Officer Schneider, is the driver of the red SUV that you've just described for this jury present in this courtroom today?
Objection,
Yes.
hearsay.
Can you please point him out by where he's seated and what he's wearing?
He is seated over here at the table wearing a gray suit.
That's the man you saw driving the red SUV as it sped past you?
Yes, it is.
The state called witnesses throughout the week. Emotionally charged and traumatic testimony came from Kelly Grabow, who had been at the parade with her daughter, Adelia. She testified that the SUV knocked her to the ground. She then saw her daughter in the street, her daughter's shoes and glasses down the road.
And I seen her in the middle of the road, which I don't know how she got to that position from where I seen her last, but she was lying in the middle of the road, and there were some people around her trying to help her. Her shoes were down the road, as well as her glasses.
Adelia was lucky to survive, and Kelly stressed the eerie detail that she had never heard a horn like Brooks had claimed.
Would you just repeat your answer, please?
I did not hear a horn.
Thank you.
Next, Jeffrey Rogers, president of the Waukesha Blazers youth baseball team, who was present at the parade with his 2 children and team members. Both of his children were injured in the incident. He described the heart-wrenching scene where, after the red SUV had barreled through the crowd, he found 8-year-old Jackson Sparks, one of the victims who passed away, lying motionless in front of his vehicle.
What observations did you make of Jackson?
Jackson was motionless on the ground, eyes open, didn't appear to be aware.
Did he appear to be alive?
Was unsure.
Did you find out that he died as a result of being struck?
I did.
Strikingly, Jeffrey too confirmed that he had never heard a horn.
Did you hear a horn honking?
I did not.
During cross-examination, Brooks seized his chance to challenge the state's evidence, yet his interaction with Jeffrey Rogers took an unexpected turn. Brooks took a full minute pause, apologizing to the court for the delay, but he got a bit too emotional.
I apologize to the witnesses. A little emotional right now for me, so I apologize to the court as well for the delay.
Whether this break was genuine sorrow or an attempt at a calculated move remained open to interpretation, but despite crocodile tears from the man who caused this pain, the courtroom echoed with the real grief and tears of families forever scarred by the events of that tragic day. As the dam of damning evidence and witness testimony continued to burst open, Brooks attempted a bold maneuver. He called the state of Wisconsin to testify.
And you have simply put on here, state of Wisconsin plaintiff, that's an entity. You have to name a person, sir.
The judge explained that the state of Wisconsin was not a person. Unfazed, Brooks insisted that he had a right to face his accuser, a clear play on his Sixth Amendment rights, as if he had uncovered a loophole to exonerate himself.
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser? If I'm not able to face my accuser, then how can the claim even stand?
Even as this courtroom drama unfolded, even more harrowing testimony deepened the tragic narrative of that fateful incident.
Oh yeah, I heard and saw the impact.
Tell us about that, please.
Heard a car hit another car, or an abutment, or a deer. If anybody's ever hit a deer with their car, you've heard it. I watched the body fly up onto the hood, and her head snapped back, and the body remained on the hood as it passed the side of my vehicle to where I thought I could have just reached out and grabbed her.
The courtroom shifted once more as the evidence painted a grim portrait of the damage caused that day. Prosecutors presented images of the battered SUV that bore the damage of the relentless rampage that happened at the parade. Brooks was doing everything he possibly could to downplay the atrocity that he'd so obviously committed. At one point, he even objected to the parade crash being called an attack during a damning moment where it was pointed out that even after the truck had been taken in as evidence, it still had a Christmas hat caught in the hood.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
Your objection is noted, and the answer will stand. I will instruct the witness to simply describe what he is seeing without further characterizing it, as it will be up to the jury to determine the facts in this case.
One witness estimated that the car hit around 15 people of the group she was with during the parade.
Did you see the red SUV strike any people in the Catholic community group?
Several.
Can you estimate how many?
At least 15.
Brooks repeatedly tried his doomed strategy of trying to convince witnesses that he was not who the witnesses said he was, and every time it fell flat, with one particularly pathetic showdown with the man who found Brooks in his yard after the crime.
Sir, Mr. Brooks, do you have any questions for this witness?
Yes, I do, and I object to being called that name for the record. Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
who's you,
or mixed.
Who's you?
Hold on, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time?
I was giving a general description.
So it would be fair to say that you weren't sure?
I was positive that it was you.
Who is you?
You. I'm looking at you.
In one particularly pathetic day of the trial, Brooks went on a 50-minute rant. He opened by refusing to consent to be referred to by the name Darrell Brooks and calling himself a third-party interviewer making a special appearance.
Consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party interviewer on special appearance on behalf of my client.
Brooks would go on to look for strange legal loopholes, asking if he can face his accuser, which is the state of Wisconsin, and saying only a living human can make a claim, and that he wants the case dismissed due to failure to appear by the plaintiff, and saying that the charges can't even exist.
That is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is a living human being can only make a claim. An entity cannot make a claim. I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. As we see here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record a non-responsive answer. A non-responsive answer is an agreement. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being.
Brooks would complain that he only had 3 days to come up with a defense and that he's just winging it.
I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes.
He would ramble on about these points and other incomprehensible angles for 50 minutes, and the prosecution would clap back, citing a prior case where someone had tried to jam up the legal system with incomprehensible jargon like this.
This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states, the majority of Retzlaff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. Mr. Brooks knowingly
call that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today, the resources of the state, the knowledge of the law, his ignorance of the law, and his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive.
Brooks clapped back with high-level legalese, calling the prosecutor's argument a load of crap.
Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
Brooks continued to cause a scene in the courtroom each day that went by, at one point snapping at the judge and telling her, "Don't nobody tell me what to do," because he's a grown man with kids.
You're advising me to be quiet? Is you telling me to be quiet?
To be respectful when the
Are
jury
you telling
comes
me
out.
to be quiet, or are you asking me?
I'm asking you and advising
Okay,
you.
thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you lower your tone
adults
of
in here.
voice
I've
and
never
not yell
told
at
you
me,
to
sir.
do anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. but somehow I'm being intentionally disruptive. Come on, man, stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work. You're supposed to be scared of getting removed or something.